So, welcome today to our Chairing a Disciplinary Hearing webinar that is being facilitated by HR Recruit and Nathan Andrews from Frettens Solicitors. My name's Jo Thompson and I'm a consultant for HR Recruit. I'm joined today by Nathan, who will introduce himself shortly. Nathan will draw on his professional experiences handling disciplinaries to share tips and best practice in handling the grievance procedure. If you've got any burning questions during the session, then please put them into the chat box facility and we will cover them at the end. I'm now going to hand you over to Nathan, who will introduce himself and start the webinar. Thank you.
Thank you, Jo. It's nice to be with you all again. So hello to everyone who's joined the call. Some of you may be familiar with me. I do present with Jo on quite a regular basis. So if there are familiar faces or names on the call, then it's nice to be with you all again today. Jo, just give me a thumbs up if you can see my slides moving.
Yep, good.
Perfect. Thank you very much. So as Jo said, most of you, if you have attended previous events that I've delivered before, that you will know that my name is Nathan Andrews. I work at Frettens. I've spent the last 20 years in HR practice. Just to make everyone aware on the call, I'm not a solicitor. I am a qualified HR practitioner, and I work alongside our employment legal services team. So we kind of offer complementary HR services alongside the work that the employment team do from a legal perspective. So today's session is how to approach chairing a disciplinary hearing. So just to give you an overview of what we're going to talk about today, we're going to touch on selecting a chairperson, so the person responsible for overseeing a disciplinary process where it's going through to a formal disciplinary hearing. We'll talk about setting up the disciplinary meeting itself. We'll also cover things to consider before the meeting. We'll then talk about the right to be accompanied, holding the meeting itself, so a framework that you can follow. We'll discuss adjournments, concluding the disciplinary process, decision-making, and following the meeting and the decision-making process, what you should do next. And then following that, we'll have a Q&A session at the end. So I will answer questions at the end of the presentation. So if you just bear with me as we work through the slides, and then we can spend some time going through any questions you may have. So the first thing to think about when you're dealing with a matter, and bearing in mind on this session, we're not talking about any investigation stage. This session is very much positioned following an investigation where there is a recommendation that formal disciplinary action may be appropriate in the circumstances. So we're going to pick up from the basis of you've had an investigation, you've received an investigation report, and it's made recommendations that the matter should be referred to a disciplinary officer for their consideration. So the role of a chairperson in terms of a disciplinary hearing is to essentially ensure that the meeting is conducted fairly and responsibly. That is the remit of their role, and it's a very important role if we're to make sure that we mitigate any risk of there being a claim concerning procedural fairness. So this is an important point to consider and to bear in mind. A chairperson of a disciplinary hearing should also keep in mind the rules of natural justice. This is often a new concept to people when I'm coaching line managers who are potentially going to go in and handle a disciplinary hearing. So what we mean by the rules of natural justice, it is a legal concept, but it is essentially about an employee being given information and knowing the nature of any allegations that are being made against them, which will be considered at that disciplinary hearing. So that's the first point, an important point to remember. They should also be given the opportunity to state their case. So during the disciplinary hearing itself, you should, or the chairperson certainly should, set out the allegations, the nature of the complaints being made, covering any or reviewing any evidence that have been gathered at the investigation stage, and then allowing the employee, so the respondent, the opportunity to respond to those allegations and to essentially state their case from their perspective. The third and final point under natural justice is that the disciplinary panel, or if it's a single chairperson, they should be unbiased and they should also act in good faith as they work through that process. So that is the concept, or the rules, as we call them, of natural justice, and something you should bear in mind as you're working through a formal disciplinary process. Now, the chair of the meeting should also ensure that the principles contained within the ACAS Code of Practice on Disciplinary and Grievance Procedures are followed. That is another important point. Now, we all know that the code is not legally binding, so an employer isn't going to be liable to legal proceedings if they fail to follow the recommendations set out within the code. But an important point to remember is that employment tribunals will take into account whether the employer has failed to follow the code or not. And as most of you will know, particularly those in an HR role, an employment tribunal can adjust any award by up to 25% for an unreasonable failure to comply with the provisions of the code. So this adjustment can be up or down depending on which party is at fault. So it's always important to remember on the part of an employer, follow the code. Failure to follow that could have a detrimental impact if you were unsuccessful in defending that claim and an award was given on judgment from the tribunal. There is an overriding obligation on employers to act reasonably in carrying out dismissal. So that is an important point again to note, and I'm sure most of you will already be aware of this. So the chair should also ensure that the employer's own disciplinary procedure is followed and that the overall process is fair. So it's an important point to remember that if you're handling a disciplinary procedure in practice, make sure you're familiar with your disciplinary policy itself. Make sure that we're clear on whether it is contractual or non-contractual. In an ideal world, your disciplinary policy will be non-contractual because that gives you some flexibility in terms of how you manage issues in practice within your organisations. If, however, and I do work with client organisations where they have contractual disciplinary policies, it is absolutely essential that you follow your policy to the letter. Otherwise, you risk facing a breach of contract claim. So if you have contractual policies in place, make sure you follow them. Don't miss any action steps as set out in that policy because you are at risk of a claim being made against the organisation. Just to very quickly touch on fair reasons for dismissal. So often when we think about a disciplinary hearing or a disciplinary procedure, we often think about, gross misconduct matters, which could give rise to the organisation making a decision to summarily dismiss an employee. But we often need to give consideration to, or we always need to give consideration to, the 5 potentially fair reasons for dismissal. And those are conduct, capability, redundancy, a statutory illegality, or some other substantial reason, so SOSR. So again, just a whistle-stop refresher on those particular points. Now, I want to move on to how you choose or select an appropriate chairperson when you are dealing with a disciplinary matter in practice within your organisations. So the chairperson should have the necessary authority under the terms of your disciplinary procedure to be able to conduct that hearing. Some procedures are specific as to who can chair a particular hearing, and some policies are very specific in terms of who has the authority to impose sanctions. So some policies will limit, junior managers to maybe a first written warning, and they may say that only senior managers or director level officers of the company can impose sanctions such as dismissal. So again, just looping back on the point I made earlier, if your policy is contractual and it does stipulate, appropriate roles or levels of, roles which has levels of authority to make decisions, you should comply with that. But even if your policy is not contractual, it is absolutely good practice to follow your policy. If you don't follow your policy, you will leave yourself open to challenge and criticism for not following the policy as you have written it and introduced it to your organisation. If dismissal is a possible outcome, it is important that the case is heard by somebody who does have that authority to dismiss. You don't want to find yourself in a situation whereby somebody has heard the disciplinary case and they then have to adjourn and consult with decision makers before they can reach a decision. So it makes it a much smoother process to make sure that you have the right level of person dealing with that hearing. So if it's potentially a gross misconduct matter where within your organisation, and particularly this is the case in smaller organisations where they will often say it has to be a director of the company, make sure that you are complying with that policy and so you can deal with the process in line with the policy as it's set out. The chair should be untainted by the process, and what we mean by that is they should have had no prior involvement in any investigation or the matter that which led to the decision to refer to a disciplinary hearing. So it's really important that whoever hears that hearing, they are independent. Now, it's not always possible. I work with organisations, we have client organisations who are very small and they don't always have the luxury of having multiple members of a management team, for example. But good practice is that you would look to have one person who would do an investigation and then another person to hear the disciplinary hearing itself, and potentially a separate person for any appeal if that was appropriate in the circumstances. So I appreciate that if you're working in a small organisation, that might not always be possible. But the one thing we always advise is if you don't have, a big enough management team to cater for, offering that kind of approach, then what we would recommend you do is consider using an external HR consultant, by way of an example, who could then come in as an independent person, and then that avoids any issues being raised. For example, if you had a person chairing a disciplinary hearing, but they were involved in the investigation, what you don't want is for the respondent to say, well, actually, the outcome was predetermined or prejudged because the person chairing that hearing was involved prior to the hearing taking place. So just something else to bear in mind. I'm sure lots of you will already be aware of that. The chair may hear the case alone or with other members of a panel. Now, that will be dependent on your disciplinary procedure and/or custom and practice. So it depends what you do as a matter of course in your organisations. But a chair can hear the case on their own, but with HR support and advice in the background. Now, what I would say is, if your organisation adopts an approach whereby you form a disciplinary panel, then you should be clear on the decision-making process and how much weight each member of that panel has in terms of making decisions and contributing to those decisions. Now, if you have a member of the HR team on that panel, we need to be clear: are they a decision maker, or are they purely there in an advisory capacity? Most typically, in the work that I do, you'll have one chairperson and HR present to take a record of the meeting and to give advice on matters of law and process. But again, I have worked with organisations where it's normal, it's often in public sector organisations, where if a matter is going to a disciplinary hearing, you will have a panel, normally a 3-person panel in my experience, led by a chairperson, and you may have a member of the HR team there and another member of the management team, and they each have equal weight in the decision-making process. So that's just something I wanted to touch on. But as I say, most typically, and I'm sure it's the same in your organisations, you will refer the matter to a disciplinary officer. That person is the chairperson, and they're supported by HR. Just to touch on, I touch on this a lot when I do these types of presentations. If HR is supporting a disciplinary hearing, they're there to support the chairperson, to take a record of the meeting and to provide advice and guidance. They should be really clear that the remit of their role is purely there to provide advice and guidance. It's not there to make decisions or to influence the decision maker. So if HR is involved, and there is case law on this, but if HR is involved, we should be really clear that we don't overstep the remit of our role. You don't want to put yourself in a position where you're challenged over trying to influence the outcome of a hearing, because that really is for the chairperson if you're in a situation where the disciplinary officer is the sole decision maker. So just to touch on that. So setting up the meeting, employers should take care to arrange a disciplinary hearing properly. This is something that I see happen quite often, where steps are missed. Arranging the hearing is rushed, a letter doesn't go out in time, and so on. So it's really important that if you know a matter is going to go to a disciplinary hearing, that we take the time to arrange that meeting properly, to make all the arrangements, to make sure we have the resources available, etc. So I can't labour that point enough. I think that's a really important element of handling the disciplinary process, making sure that we're organised and considered in how we make arrangements. You should write to the employee. You should give them reasonable notice of the date and the time of the meeting. So, for example, I always say, depending on the complexity of the matter, I certainly wouldn't advise a shorter notice period than 48 hours. Often I'll give longer if I'm dealing with a particularly complex matter where the evidence bundle we're going to be referring to during the hearing is considerably large. I'll often give 5 days notice so that the individual, the respondent, has time to not only review the letter you sent them, which should set out the nature of the allegations being made against them, but they should also be able to review the evidence meaningfully, obviously make their own notes and set out and present their case in a way that they will be then able to articulate to you during the hearing. You should always be clear in your letter that the meeting is being held under your disciplinary procedure. You should provide written details of the allegations. I've already said that, but just to touch on that again, really important. Be specific, be clear about the allegations you want to discuss. I always say avoid introducing anything new on the day unless that's unavoidable. And if you do introduce a new allegation and there is new evidence to be considered, and you are only telling the respondent on the day of the hearing, what you should do is inform them at the hearing, at the start of the hearing, there is additional allegations you want to discuss with them, and you should give them copies of any evidence that you have gathered, and you should take a reasonable adjournment to allow them to review any new evidence that you are providing to them on the day. Really important point. Ideally, that won't happen, and you'll be able to give them everything in advance with proper notice, so when they attend the hearing, there are no surprises for anybody. If an employee is left surprised or shocked by the allegations you're presenting to them, that would suggest that we've not done a good enough job of really setting out the issues to be discussed and addressed at that meeting. We should provide details of any evidence, I've already talked about that, but it's any evidence supplied by employees, any evidence you've gathered as part of your investigation. So it could be witness statements, it might be emails, it might be letters, it could be, IT logs for, accessing systems and so on. Anything you gather as part of an investigation, not you, but, if you're the chairperson, you won't have been involved in the investigation, but anything the investigating officer has gathered, which you are going to rely on at that disciplinary hearing, that should be made available to the employee. So they should have everything that you have. So again, there are no surprises. That's a really important point. We should also always inform the employee of their right to be accompanied at the meeting. And as we know, that is either by a colleague or a trade union official of their choice. And we should state that the outcome of the disciplinary hearing could be dismissal or any other sanction that might be appropriate in the circumstances. What I typically like to do is I will always say, just have a blanket statement in any letters that I will issue that will say that potential outcome of the disciplinary hearing could be a disciplinary warning or dismissal. So depending on what you're dealing with, you have covered all bases, because essentially what we don't want to do is for an employee to turn up to a hearing and suddenly say, actually, I hadn't realised that you may have been considering dismissing me, and that would have impacted how I stated my case or engaged in the process. So I think that is really important. Final point for me on this slide is that the meeting should be held without unreasonable delay. This is really important, and it's something I see often in practice where there are long delays between an investigation and then a disciplinary hearing taking place. And sometimes that could be that the investigation was overly complex because of the nature of the allegations under investigation. And that could mean that the evidence gathered by the investigating officer was substantial. It was a large bundle, for example, and that people needed time to review that and read that before they made a final decision about whether they wanted to invoke the disciplinary procedure. But it is unhelpful. Having an unreasonably long delay is unhelpful to the process. It can further damage working relationships and cause tension, could give rise to grievances. These are all things that you want to avoid, particularly when you're dealing with serious misconduct issues. We want to be able to demonstrate that we've been whiter than white in terms of treating our employee fairly, following our process to the letter, and making sure that we take into consideration their welfare and their well-being, because these processes can feel very stressful. So I think that again is an important point to make. And we should also, and I'm going to labour this point, make sure we give the employee reasonable time to prepare their case. Otherwise, again, that could give rise to further complaints or criticism later on. So failed to plan to fail is something I'm sure you've all heard before. It's something I certainly talk a lot about when I'm working with my clients in terms of handling a disciplinary hearing. So the chair and any other panel members should be familiar with their disciplinary procedure, and they should also have access to the ACAS code. So when I'm working with client organisations, I will always say, do you have a disciplinary procedure? If you do, are you familiar with it? If you're not, please make sure you review that policy or procedure in detail. It could be that as you go through the disciplinary hearing, the employee or the representative may ask you specific questions on the process or procedure you're following, and what you want to be able to demonstrate is you're familiar with the process, you know what you're doing, you're clear on your organisational procedure, and that you're going to follow that to the letter. The ACAS code, again, I'm a big fan of always sending out the ACAS code to line managers who are chairing disciplinary hearings in advance of that hearing, particularly for managers who aren't, say, particularly familiar with chairing this type of hearing. And the reason I do that is it's good information for them to have. And again, if they're asked any relevant questions from the individual, the respondent during the hearing, or from their representative, again, it instills a level of confidence in the respondent and their rep when they know that you are familiar with the ACAS code and that you're working to that code and acting reasonably in the circumstances. So always bear that in mind. Prior to the meeting, I always say that the chair should review all the facts. So a thorough investigation should have been conducted prior to the disciplinary hearing being convened. and you should review those facts. If you are the chairperson, it is your responsibility to review the bundle prepared by the investigating officer, to go through that in detail, annotate it, identify any questions you want to ask, anything that stands out to you, and you want to be able to demonstrate that you've done that you're familiar with not only the allegations being made, but the evidence that has been gathered as part of that process. So absolutely, we want to make sure that we do justice to that that kind of preparation work in advance of the meeting. Now, just to cover very briefly, a good investigation report. So if you've appointed an investigating officer who is familiar with investigative practice, they should produce you a pretty structured, decent investigation report, which will allow you to get up to speed, understand what evidence has been what evidence is available to either support the allegations or to suggest that there isn't a case to answer, as the case can often be. A good investigation report should have an introduction. It should outline the investigation process followed by the investigating officer. It should set out their findings, it should have a conclusion, and it should make recommendations as a minimum. Now, we offer a specialist investigation service, so the reports I produce are much larger, but as a minimum, I would suggest a good investigation report will be structured in that way, and that can take time for you to review. So you want to, again, make sure that as soon as the investigation is concluded, that you can access that report and get to work in terms of reviewing the report and the accompanying evidence in advance of the hearing. Because again, bearing in mind, we don't want there to be an unreasonable delay between the investigation concluding and the disciplinary hearing being convened following that investigation, particularly where there's a recommendation that disciplinary action is potentially required. I've touched on this already, but absolutely review all documents, be thorough, scrutinise that information. Remember, if you're dealing with a misconduct matter that is so serious that a potential outcome could be dismissal, if you're the decision maker and a claim goes to the tribunal, you will be called on as that decision maker to give evidence in the tribunal and to set out your rationale for the decisions that you reached on conclusion of the disciplinary process. So it's really important that you review all relevant documents. Examples I put on the slides are look at previous warnings that are still active, look at appraisal review forms that you might be relying on that might have relevant information. You might want to look at telephone and computer records, again, depending on the nature of the complaints. Expense claim forms, could be emails. There certainly will be witness statements that you're going to want to review. And sometimes that can be overwhelming because you could be looking at quite a substantial pack of information, and you have to then scrutinise that and pull it all together to help you make decisions. So you do need to take a level of time in doing that. So hence why I say on conclusion of the investigation, make sure that you get access to that report as quickly as possible so you can start the work of analysing the evidence. Ensure that dates and times of incidents are clearly listed. Really important. I've been in disciplinary hearings supporting line managers where the respondent will say, well, when did this happen? I can't respond to that properly unless you can tell me when an incident occurred, and we've not had that information. And I think that then causes tension within the process, within the hearing itself. So it's really important that we're prepared. We've got our dates and our times set out, that you've got that listed. So if you want to discuss those key dates and times, make sure you have them to hand in a way that's easy for you to locate and find them. Plan a list of key questions that will be put to the employee during the hearing. This is something that's really important and often I see as a missed opportunity by somebody chairing a disciplinary hearing. It's often just due to lack of knowledge and lack of experience. But once you've reviewed the investigation outcome report and any evidence gathered by the investigating officer, what you should then do is step back and think about, what does all this information tell me? What questions do I have? What information do I feel the respondent may be able to help me with? And then what you should do in advance of the hearing is set out your questioning framework. And this is something I do as a matter of good practice for every disciplinary hearing or appeal hearing that I chair. I go in with a list of pre-prepared questions based on the evidence, based on the investigation report that I've reviewed. And then I work through that list of questions in a systematic order. Now, don't get me wrong, I don't allow having a pre-prepared list of questions prevent me from asking relevant questions as I work through a hearing. A respondent might provide a particular response to a question that may lead on to another question I want to ask to help me gather more relevant information. So don't allow having a set of questions don't allow it to preclude you from doing some further questioning work with the respondent during the hearing to gather relevant information. But it is very good practice to have those core questions set out so you don't miss anything, because what you don't want to do, reach the end of the hearing, adjourn, and then realize actually I've got I've got further questions I want to ask because I've got missing information. So a really important point to bear in mind. Consider the employer is likely to act in a negative or defensive way. Again, this is important, not so that, and I don't want you to kind of misinterpret what I mean by this. I'm not suggesting that we do this to, try and have a negative view of how somebody may or may not react. But what I mean by this is that if we know someone is likely to be negative or maybe defensive, it could mean that the meeting will feel tense and challenging at points. And what we need to do is, if we're prepared for that, we can hopefully take proactive steps to, build a connection with the person at the start of the hearing and hopefully defuse and reduce the tension in the hearing. Because the reality is, if you've got somebody who's very defensive, defensive body language, resistant to answering questions, it's going to make the meeting more challenging. And actually, sometimes I've seen this in practice where, you have the chairperson who becomes almost interested in their position because they get frustrated at the person answering questions. The respondent then is becoming more defensive because they feel like they're being asked questions to almost, trip them up. And that's often not the case, but that's how somebody potentially can feel. And so it's really helpful to just have that thought process at the beginning to give you an idea of the character and how they might respond and how you can best support them to engage in the process in a really meaningful way. So I think, yeah, again, it's all about preparation. If you do the prep work in advance, it can be hugely helpful to the process. So just something to bear in mind. I'm not going to go into huge amounts of detail because most of us, that I'm sure there's probably not anybody on the webinar today that doesn't know that an employee has the right to be accompanied. But just to make you all aware, it is the chairperson's responsibility to make sure that the employee has been made aware of their right to be accompanied at the meeting. It's one of the first things I cover. If I'm chairing a hearing, I'll say to the individual, we wrote you on X date, we invited you to attend this hearing, we set out the following allegations, and you were also offered the right to representation. Can you please confirm you've received our letter of X date? Are you familiar with the allegations that we're going to discuss with you today? And were you aware that you have the right to be accompanied? If they attend the hearing without a companion, what I do is I just ask the question, you're here alone. Do you want to have somebody with you? If you do, I'm happy to adjourn and we can reconvene when you have a companion who is able to attend with you. So really important point. If you're the chairperson, it's your hearing, you're the one in charge of that process. So it's your responsibility to make sure that you go through that process and make sure that their responses are noted. What we want to avoid is later on someone saying, I've seen this happen, I didn't realise I had the right to be accompanied, the process was unfair. And I would then say to the chairperson, did you check that they were aware of their right to be accompanied? They will say yes. And then we review the minutes. And in the minutes, that information has not been captured. So really important, just do that at front end, have a checklist of things that you need to cover off, like housekeeping bits, and I would go through it systematically and check it off so that before you start getting into the most relevant issues that you want to discuss, you've done all your housekeeping bits at the front end. Okay. Let's just see where I got to, because I realised I've talked a lot at you about the right to be accompanied. Yeah, if it does become clear that the employee is not aware of the right to be accompanied, I would always adjourn and say, well, I'd certainly offer an adjournment, but make it clear to them you do have that right to be accompanied and we are happy to adjourn and allow you to make arrangements. So I'd make it very clear that is an option open to them before proceeding. So just to make you aware of that. Yeah, this is something I will touch on briefly. It's not often something that happens in the disciplinary hearing, but obviously, as we know, the statutory right to be accompanied is limited to a work colleague or a recognised trade union representative or official. However, it will depend on circumstances, but sometimes I will allow an individual to bring a relative or a friend, for example. And it will depend on, whether I feel that's a reasonable adjustment in the circumstances. It could be that we're dealing with a particularly sensitive matter. There may be a disability involved. It may be that they don't feel they have got anyone they can rely on, as from within the organisation to support them, and I will take that into consideration. And I have, and often do, allow somebody that doesn't neatly fit into the bracket of work colleague or trade union rep, because I want to be able to demonstrate that in all of the circumstances I have acted reasonably. And it's particularly important when we're dealing with a situation where, as a potential outcome, dismissal is something you're going to consider. For me, I always say gold standard. If you can demonstrate that you have gone above and beyond statutory minimum requirements when dealing with employee relations issues, that goes a long way to you defending any potential claims that might be brought against the organisation. So just to bear that in mind. We can talk. I'm sure you may have questions on that later. It's normally one that generates some questions. So on the day of the hearing itself, it's always advisable to have a note taken at the meeting so that a written record is kept. I can't stress this enough. I've dealt with cases where a line manager's attended hearing on their own, taken their own notes, and that can get messy because you're in a situation where it's one person's word against the other. The respondent might say, well, actually, I don't agree with the notes because that's not what was discussed. And then you've got this conflict, and it's not a conflict we can then easily resolve. And I've dealt with situations where somebody has attended and chaired a disciplinary hearing as a lone chairperson, taking their own notes, and we've then had to restart the whole process again by doing it properly, because they then took advice from us. So really important, never put yourself in a situation where you are on your own. Make sure you've got somebody with you. Just to touch on, anyone that's been on calls with me before will know, when I'm dealing with an investigation, a disciplinary hearing, a grievance, or an appeal hearing, I record those hearings. Everybody in attendance is made aware that we are recording the meeting, and then I send my recordings off to a transcriber, and that transcriber will provide an intelligent verbatim transcript. So they will, remove any kind of repetitive words or, the ums and the ohs and the ahs, but they will give you a very, very accurate record. Now, the reason I prefer to record is I think if I'm not recording, the likelihood is the respondent may be recording the meeting. I often find it very difficult to agree written notes that are typed up, because with the best will in the world, unless somebody knows shorthand, and that's not often a skill you see in today, someone taking notes by hand will miss information because there's only so much you can capture, and often that gives rise to issues with agreeing notes and records and so on. And so for me, it's just really helpful to have an accurate record, and the best way of doing that is by taking a recording. Obviously, we absolutely need to be telling everybody present that you're taking a recording. We should not ever take a covert recording as an employer. That's strictly a no-go. And also, I think it is just helpful to have a recorded record of the meeting. And what we do is, when I'm working through a disciplinary process as an example, and we're recording that hearing, I will say to the person, we're recording the hearing, we will prepare it, we'll have a typed transcript prepared from the recording. If you would like a copy of the recording, that's absolutely fine. We'll give you a copy and we will retain a copy, but we won't work from that recording. We will work from the typed transcript. So I'll say to the employee, we're going to send you the transcript along with the recording if they want a copy, and we'll ask you to review the transcript and to sign off on that transcript, and I'll do the same. Now, typically what happens is an employee says, I don't want a copy of the recording, I'll be happy with the transcript. And what we say to them is, if you're not going to have a copy of the recording, we won't retain one, we will permanently delete it. And then we will just hold on to the agreed transcript, but we'll only permanently delete the recording once the transcript is signed. So just to talk to you about how I practice, and as I say, I've been recording for the last 3-4 years now, and actually it makes agreeing records of meetings much more easier because it is an accurate record. Just going back to the slides, so as a chairperson, you should absolutely outline the procedure you're going to follow during the meeting. There shouldn't be any surprises, be clear. I always say clear is kind, unclear is unkind. There should be no surprises. So the person should be very aware of the process you're going to follow during that meeting. And you should introduce any parties who may be unknown to one another. So if you've got a trade union official that you've not met before, make those introductions so we're all clear on who each other are and the remit of roles, etc. You should check that the employee is fully aware and has had advance notice of the disciplinary charges or allegations being made against them. So again, do that and make sure that you capture that in the records. If you've got a note taker, make sure that your note taker is capturing those responses. These are really important bits of information. And you should also check the employees receive copies of any documents that you're going to rely on during that meeting. So that's really important. I don't think there's anything else I want to say on that. No, obviously, if you are going to introduce, as I've said already, if you are going to introduce any new information or new evidence that's come to light that hasn't been made available to the employee, make it available to them at the start and take an adjournment as necessary. So if it's only, 2 or 3 documents that's going to take them no more than half an hour to read, then adjourn for half an hour. But if you're giving them substantive new information, it might be appropriate to adjourn for 24 hours or 48 hours, depending on the information that needs to be reviewed. So just bear that in mind. You should explain the aim of the meeting, which is to establish facts and to seek a resolution to any problems you're trying to address. Be systematic, so list the issues you're going to discuss. Put all the evidence of misconduct to the respondent so that they have the opportunity to respond fully. Break them down, so break it down into component parts. So, split out the allegations, present them, and ask for their response, and capture their responses to each allegation being made against them. Explain the problem objectively. So I think that's really important. When you're a chairperson, be objective. Give specific examples. That adds a lot of weight to your discussions. If you can give examples of any kind of unacceptable conduct or behaviour that you want to address with them, it brings the allegations to life essentially, and also it makes it really relevant when you are presenting allegations and evidence to the individual, because you can then draw on those examples to support your position. As always, ask open, probing questions to gather relevant information as you go through the process. That's really important. And just remember the remit and the role of a representative or companion is that they're not there to answer questions on behalf of the employee, but they do have the right to put the employee's case, to sum up their case, or to respond on the employee's behalf to any view expressed at the meeting. But as I say, they shouldn't be answering questions on behalf of the employee. And if that becomes an issue, that's something you need to challenge and to prevent from happening. You are responsible for the conduct of that hearing. It's your hearing. And so you can appropriately and respectfully challenge when someone is overstepping the remit or the boundary of their role. What I tend to do when I know somebody's going to be accompanied is at the start of the meeting, I set out, as per ACAS guidelines, or I set out the role of a companion. So at the beginning of the meeting, I say, this is the remit of your role, and I'd ask you to respect those boundaries. So again, and I get that documented. So we're all on the same page at the start, and it makes for a much more straightforward, smoother experience as you work through the process. So we come to adjournment. So you've gone through the hearing. You now need to, you've presented the allegations, you've reviewed all the evidence, you've gathered the respondents' responses to those allegations, and you now need to take an adjournment to make a decision about what the outcome of the hearing is going to be. So, if you become aware of any material breach of your disciplinary procedure, really important point to note, you should make an adjournment, consider what that breach is, and work to remedy it and to make sure that you are in compliance with your own policy, particularly where your policy is contractual. So just make sure that you are following that policy to the letter. That shouldn't be an issue if at the front end you've familiarised yourself, if you're the chairperson that is, you've familiarised yourself with your own policy. An adjournment can be brief. For example, an hour to read documents. So as we've talked about, if you've got new information, then that can often be an appropriate length of adjournment. You will need to exercise discretion and apply, a reasonable approach in each situation. You want to be able to demonstrate you've been reasonable in all of the circumstances. So I can't stress that enough. In these situations, when you're caught up in reviewing a matter, particularly when you're dealing with serious misconduct issues, it can be very easy to get frustrated with somebody. But what we need to do is not allow that to cloud our judgment or us adopting a reasonable approach. If it transpires during a meeting that new matters have arisen that require further investigation, then absolutely what you should do is adjourn to a later date to allow further investigation to take place. And what I would typically suggest you do in those circumstances, if there's new matters which come to light or there's missing information, it might be that you want to refer back to the investigating officer and to ask them to go and investigate those further issues. Alternatively, it may be that they're straightforward and all you need to do is speak to a couple of people to establish, facts or information whereby you could take a short adjournment and do that work yourself. But if any new matters are substantive in nature and you have had an investigating officer who was instructed to conduct an investigation, I would refer that back to the investigating officer for them to investigate, and then they can amend the investigation outcome report before you reconvene. If the employee or witness becomes upset or distressed during the meeting, then absolutely we should ask if they would like to take a break. Sometimes somebody will say, no, I'm fine, I'll continue, but actually it's clear that, they need to have a break and they need to compose themselves. And often I would just say, look, let's take 15, 20 minutes, go and get a coffee, compose yourself, and we can reconvene when you feel ready. So again, just demonstrate that you're being reasonable throughout the process, and make sure if you do something like offer an adjournment because somebody becomes upset, that you document that as well. So concluding the meeting, once you're satisfied that all relevant matters have been raised and discussed, so you're happy that you reviewed the evidence, you've put the allegations to the employee, you've captured all the responses from that individual, then what you need to do is then bring the meeting to a close so that you can then take the time to consider what you're going to do next. If obviously you're part of a panel, you're going to have panel discussions, but most typically you're going to be a lone chairperson, the lone decision maker. So what's involved in this process? So it's checking if the employer has anything else that they would like to add. Really important, and it's really important you capture that in the records. So I always say to the individual, look, this, I've asked everything I need to ask today. So before we conclude, is there anything you feel I should know and take into consideration as part of the process? So I make sure I'm really clear with that. I always like to summarize the key points that have been discussed. So it might be helpful as you're working through the process, you're taking your own notes, even if it's just in bullet format. Obviously, you don't want to be busy making your own notes and then actually not engaging with the respondent in a meaningful way. But I will often scribble notes as I go through, just so it aids my kind of overall ability to summarise at the end. If any action points have been agreed, it depends on the matter that you're dealing with, of course. Typically if you're dealing with a gross misconduct issue, this may not be relevant, but if any action points have been agreed, restate those so we're all clear. And the respondent is clear what's going to happen in the future or what changes in behaviour have been agreed to avoid any further issues. So again, be considered in your approach there. Advise the employee that a decision will be taken as to whether a disciplinary penalty will be imposed. And you also want to be clear on what the type and level of that penalty may be. So again, be really clear with them so that there are no surprises. Advise the employee when and how they're going to be informed of the outcomes of the decision you make. So again, what you want to do is avoid someone chasing you. So it may be, if you're dealing with a particularly complicated matter, you may say to them that I'm going to need to take 48 hours to consider my position in terms of what I think an appropriate outcome is. I certainly would never make a decision on the day. If it's a very straightforward issue where you're only looking at, a first written warning, for example, there's nothing wrong in adjourning for a reasonable amount of time, say an hour, to consider before making your decision. But you certainly shouldn't make, I'm absolutely advised against taking a 10-minute adjournment and then come back and going, here's the outcome. But if you're dealing with a matter, particularly a gross misconduct issue, I will often say to an employee, take 24 hours, take 48 hours to consider your position. It's really important to do that because what you want to do is you want to avoid the employee trying to suggest that any decision that you made was predetermined or prejudged. So taking a reasonable amount of time as appropriate in all of the circumstances is a really helpful thing to do. So don't feel pressured into the timeline of when you should make a decision, but be clear with the employee when you're going to give them or you're going to inform them of the outcome. So that then manages their expectations. I think that's really helpful. As I say, there shouldn't be an unreasonable delay in communicating the outcome. So any delay, so the length of the adjournment should be reasonable and it should take into consideration the circumstances and the complexity of the case. So just bear that in mind when you are working through the process. So in terms of making a decision, as we said, you should adjourn the meeting to consider that decision. A reasonable period of time should be allocated. And an over hasty decision should absolutely be avoided. I don't need to touch on that because I know we've already spoken about that, but they're on the. I put those points on the slide for a reason because you're going to want to be able to rely on this if you are challenged later on. So just be really clear on those points. And that brings us to a conclusion for the presentation. I put on the slide just information for you in terms of events we've got upcoming, if that's of interest to anybody that's local to us. And you have got the contact details for the team here at Frettens. We've got the employment team, which is headed up by Michelle Kemp, supported by Chris Dobbs, Kate Fretton, and Justine Mears, the employment legal services team. And then you've got the HR services team, which is headed up by myself, supported by Francesca Dixon. And yeah, I'm happy to hand back over to Joe for any questions.
There's loads, Nathan. Right, so a lot of these are going back to right at the beginning. So Sarah's asked, do they need to know who has made the allegations?
Yeah, typically if an employee is going, so this goes back to really kind of the concept of natural justice, really. So for an employee to be able to respond to allegations being made against them, most typically they're going to need to know who's made those allegations because the employee is likely to argue if they don't know that information, they're likely to argue, how can I respond in a meaningful way if I don't know who's bringing those allegations against me? It might be that they would say, well, actually, if they were to later on find out it was a particular employee, they might have said, well, actually, had I known it was that individual, we had a disagreement, we weren't on good terms, etc. So my view is, absolutely, there are times when we need to take into consideration confidentiality. But the one thing I always say is we should never give a blanket promise to anybody bringing complaints to us that we can guarantee their anonymity and or protecting their confidentiality in terms of the complaints they're bringing. And the reason I say that is often if you're going to have to look at very serious matters that could result in someone being dismissed, say, from their employment, they need to be given a reasonable opportunity to state their case. And by us, preventing them knowing who's made complaints, it could be argued that prevents them from being able to do that in a meaningful way.
Thank you. Deirdre's asked, do you have to provide the whole investigation report prior to the meeting or just put the main allegations in the invitation letter?
No, most typically, I would say that you would give them a copy of the investigation report because ultimately you're going to be relying on that information, so the information contained within, through the hearing. So there's no reason why they shouldn't be given a copy. Now, it might be that you need to make redactions, so it might be that there is information that they shouldn't have access to, and then what you would need to do is look at redacting that and then sending them a redacted PDF copy. I have worked with client organisations who have been completely resistant to giving a full copy of the report, and what they do, they will take extracts from that report. But the reality is that investigation report is going to be about the respondent and their conduct or their behaviour. And if they were to submit a data subject access request, I think you're going to have a hard job to argue that they can't have access to that information. As I say, you can absolutely redact information that they shouldn't have in order to protect data protection principles. But yeah, I would say that unless we've got good cause not to give them an unredacted copy, we should be giving them a copy of that report.
Okay, Jessica's asked, in cases of potential gross misconduct, who should chair it? Our procedure doesn't set out authority for sanctions.
Yeah, and if it doesn't set out authority, then what I would say is, reasonably, if you've got a sufficient size management team, you would look at, somebody relatively senior enough to be able to make a decision to dismiss somebody, and then you would keep, a layer above them to handle any appeal. So I think when you think about who should we get to do the hearing, in an ideal world, it potentially would be the employee's line manager. So if you're dealing with a matter where the line manager isn't involved, they're not a witness, they've not had any involvement in the investigation, then the line manager could chair the disciplinary hearing, and the line manager's manager could then be available to hear any appeal. Sometimes it's not always that straightforward or clear cut. It depends on the size of the organisation. But what I would say is, if you don't stipulate that in your policy, that's fine. It means you've got some flex in terms of how you approach that. But what you should do is make sure that, whoever's making the decision at the disciplinary stage, they have the authority, they're seen enough to do so, and that with the best of the world, you have somebody above them who can hear any appeal. Now, if you haven't got that kind of management structure, it could be that you've got, a very flat structure where you've got a senior management team, and you might have an ops manager, you might have an HR manager, you might have a finance manager, and it could be that the finance manager does the disciplinary, and the ops manager, whilst being on the same level as the finance manager, hears the appeal, but both should have the ability to make decisions. So typically what we say is, at the appeal stage, you want to know that somebody chairing that process has the authority to overturn any decision made by the disciplinary officer. So I hope that answers that question.
Okay. Nicholas asked, would the investigation report itself be provided to the employee or sections from it? You might have touched on that.
Yeah, we touched on that. I would give, unless I've got good reason not to, I would give a full copy of the report, the investigation outcome report. It often, certainly when I'm instructed by a client as an investigating officer, I will make decisions about whether I need to redact that report. But the redactions are purely about protecting our compliance with GDPR and data protection. So I will only redact information about other parties that isn't relevant and the respondent shouldn't have access to. Other than that, I try and avoid making redactions, because again, if you make lots and lots of redactions in the investigation report, you're going to leave yourselves open to challenge, because the employer will say, well, look, I didn't really have a fair shot at stating my case because the evidence that was presented to me was heavily redacted. So I was unclear about the allegations being made or who made them. It's really unhelpful. I think if you want to build trust with employees going through these processes, then we need to be open and honest. And that's an important point when you're investigating. If you are an investigating officer, when you're interviewing witnesses, we make clear to the witnesses, look, this information we're gathering is likely to be made available to the respondent. And so we cover that off early doors. Because some people say, oh, I want this information to be confidential. I don't want them to know I said anything. And actually, sometimes I have to say, look, with the best in the world, I can't guarantee that. Unless that person has a genuine, valid concern about repercussions, where I think actually I do need to anonymise this witness statement, I don't offer any blanket guarantees that I can protect anonymity in that regard.
Thank you. Tanya's asked, if someone is subjected to criminal proceedings after you have commenced your internal proceedings, i.e. for sexual harassment, what do you suggest the company does? Pause the investigation to wait the outcome, or go ahead and maybe dismiss?
Yeah, this is a really common question I get asked a lot. I think the reality is, if criminal procedures have started and the police are investigating, often it's not reasonable for employers to put on hold any workplace investigation that they undertake. There are two important points to consider in this regard. A police investigation and the burden of proof that the police will apply is beyond a reasonable doubt. So there's a very different burden of proof to the civil burden of proof that we work to from an HR employment perspective, which is based on the balance of probabilities, i.e. what is reasonable for us to believe happened in circumstances. So often I've seen cases where the police will conduct an investigation, the employers put on hold any investigation that they've undertaken, and the company at the end will conclude the investigation and still make a decision to dismiss. And an employer might say, well, actually, why have done that? The police found that I didn't commit this crime or this act, but yet you're still dismissing me. And our defense always says, well, actually, look, based on the balance of probabilities, different burden of proof, this is the decision we've made. In answer to the question about whether you should put on hold your investigation, my view is you take the circumstances into consideration, and you would need to consider, how long is it going to take the police to conclude their investigation? A police investigation can take many, many, many months. And if you've got a situation that's arisen whereby an employee's been accused of committing an act of gross misconduct, you're likely going to have to suspend them. And what you don't want to do is be in a situation where you've got an employee suspended on full pay for 9, 10 months, if not more. And so my view is, if you're dealing with a situation where the police are involved, take professional advice. Depending on the circumstances, it's unlikely I would say we don't do anything. I think what I typically do in these circumstances, we consider what the allegations, and we proceed with our investigation, and we look at making decisions about what we do next. Now, some of the challenges in that situation is that if an employee is subject to potential criminal proceedings because they're under investigation by the police, they're probably going to instruct a lawyer. The lawyer, if they then tell their lawyer that they're being pursued by their employer to participate in an investigation, their lawyer's probably going to say to them to be really guarded about what they say, or if the lawyer could even say to them, don't participate at all. Because it could be that as you investigate matters, the police could well ask for access to the information you've gathered as part of your investigation. So if you've got witness statements, for example, police could ask to see that information. But as I say, normally it's not reasonable for an employer to do nothing and not to investigate. And so take proper advice. It's likely you'll be advised to proceed with your investigation unless the matter is very, very serious and that any attempt by the organisation to investigate could jeopardise the police investigation. It's unlikely you'd be given advice not to do something about what has arisen. But what I would say and absolutely stress is seek legal advice in the circumstances. I've been doing this work for 20 years and I will still speak to my colleagues in the employment team when matters like this arise, just to make sure we mitigate risk, we cover our bases, we're acting lawfully and we're compliant. So just hit home on that. I hope that answers your question.
There's two questions here, Nathan, that
Yeah.
are quite similar. So Tanya's asked, I'm seeing an increase in people declining to attend the first appointment date stroke time. What is your view on rescheduling, but stating the second date time is set and non-attendance will mean it'll go ahead irrespective, taking into account the severity of the case and business need? The second question is from Rachel, says that she's had a similar issue, partly due to the RCN union not being available. So there's been a 4-week delay in the hearing taking place.
Good question. First of all, in response to the first part of the question, absolutely, I reschedule. So again, it goes to demonstrating reasonableness on our part as employers. And what I would say, and I normally have a standard paragraph in my letters that says, if you don't attend the meeting or you're unable to attend, please notify us. We will reschedule within five working days. I'm not rigid in sticking to these 5 working days. So if it's not possible, because say, for example, an employee's companion representative, of their choice is not available, then I would reschedule when they are available. With trade unions, this can be challenged. I do see this a lot where an employee says, actually, I want my trade union rep. So not a colleague who's taking on a trade union representative role, but they want somebody from the union itself. That can delay because you are reliant on that person's the trade union officials' availability, because often these representatives, they're very busy, they have a heavy caseload. So again, what I would say is that you have, is being reasonable in the circumstances, and taking each case on its own merits. I mean, I've seen delays where we've had to delay for 3 weeks because the employee's union rep wasn't able to attend in good time. Now, the only thing in the case that I'm talking about is that this person had a professional role, and that this was a role that required them to study for many, many years. And obviously, if we dismissed them from their employment, that can have a very significant ability or impact on that person to be able to continue working in their profession. So we adopted a very, very reasonable approach in those circumstances. It may be that if you're dealing with, if you're in a sector where it's like hospitality or something where you could demonstrate that it was not going to have a significant impact on someone's future ability to seek alternative employment, you might not want to delay for that length of time. But what I would always say is, in the circumstances, demonstrate that you've been as reasonable as you absolutely can be, and it goes a long way in helping you to defend a claim. If you're unsure, take advice. You can speak to people like me. You can speak to an employment solicitor, and they'll give you a good steer. But my approach in the first instance, in regard to rescheduling hearings or kind of allowing there to be a sufficient period for a chosen companion to attend, is just be reasonable. Yes, you can't continue to allow for reschedules to take place, but we certainly should allow. My general rule of thumb is I always allow 2 reschedules, because typically ACAS will say we should allow 1 reschedule within 5. I think it's within 5 working days. I'm talking from the top of my head, so don't quote me on that. But I would always go for 2, just so I can demonstrate to the employee and to anyone else we tried our best to meet with this person. We weren't unreasonable in our endeavours to engage in that process with them. I hope that answers the question.
Alison's asked, do you have a crib sheet or checklist already that they could utilise at the hearing?
I mean, we have this particular document that we formulated over the years that we use internally for clients. But what I would suggest you do is I mean, ACAS is really good. They often have good template documents. But yeah, go. What I would do is I would go through your disciplinary policy, look at the specifics of your policy, and create a standard checklist that you will follow. So things like, introductions, checking the right to be accompanied, reviewing, checking the person received the invite letter, setting out the allegations, ask them to confirm that they were given, they were informed of their right to be accompanied, list it out in like a checkbox format, and then you just go through that list. And sometimes you have to adapt. You adapt the checklist depending on the circumstances, but on the day you just have it next to you and you just go through it systematically and tick it off one by one.
There's a couple of questions about recording Nathan. So again, I'll just try and put them both into one. So
Fine.
Sarah's asked, do they have a right to record the meeting? Her organisation doesn't allow it. And then someone else has asked, if the employee records the meeting without the consent of the organisation, can it be used as evidence?
Yes, so an employee doesn't have the right to record a meeting, and it might be you have in your policy that it is strictly prohibited that we don't take recordings, and we certainly it certainly should be in your policy that you don't accept covert recordings. That being said, if an employee records a meeting, that can be admissible in the employment tribunal. It's absolutely unacceptable for an employer to take a covert recording, but yeah, yes, if an employee does take a recording, then that can be admissible in the tribunal, and the judge may allow it and say, actually, I think it's relevant, I want to hear it. So, hence why I say, often there is a concern. If I will speak to leadership teams who say, "Oh, a bit concerned if we record because what if a line manager says something that's unhelpful?" Well, my response always is, look, if a line manager says something unhelpful, they're going to say that whether it's being recorded or not. And if you've got a good note taker, they should be capturing that in the recording, in their notes. So if I'm recording and the line manager says something unhelpful, we can always try and remedy that. We can adjourn. If you're there as an HR representative, we can adjourn and actually just correct the line manager and then go back when you reconvene to actually say to the employee, actually, this comment was made. We want to address that so we can remedy it, etc. So you can look to course correct, and I've done that before. But for me, my perspective has always been, if a line manager says something that's unhelpful, you've got handwritten notes, and those unhelpful comments have not been captured in the notes, and then the employee later challenges it, and they have a copy of the recording. What they're going to do is say that actually the notes are missing key bits of relevant information, and then it allows them to kind of start to challenge the integrity of the process. So my view is I like to record them. It's not essential. There's no requirement in you doing it. What I would say is if you are going to have someone taking handwritten notes, make sure they can take good quality notes. And it's a skill. Not all of us have it. And there's nothing wrong with that. But it's just making sure that any person responsible for taking records of meetings should be able to do that. If they're doing it by hand, they should be able to do justice to that.
And just on that, Margaret's asked, do you tell the individual about the recording in the invite letter or in the meeting?
Yes, I always do it in the letter. So you'll be invited to attend a formal disciplinary hearing. I tell them about the potential outcome. So if dismissal could be a potential outcome, we tell them that. We also say to them in the letter, the meeting will be recorded, and then we explain why. And it's very simple. We're taking a recording of the meeting so we can prepare an accurate transcript on conclusion of the meeting. You'll be given a copy of that transcript, and we'll ask you to review it in full and to sign to say you agree that the transcript serves as a fair reflection of our discussion during the meeting. We then cover off that. Yeah, if you would like a copy of the recording, please notify us. If you do retain a copy of the recording, we will retain one on file. If you don't want a copy of the recording, we will permanently delete it once both parties have agreed the notes. So we make that very clear to parties that, if you're not going to keep a copy, if you don't want a copy of the recording, we will permanently delete it. What I do say to the individual is, if you change your mind and decide you do want a copy, you need to tell us before we sign and agree the notes, because once we do that, we will delete it, and I will permanently delete it. So I can't even access this. Once it's gone, it's gone. So we're very clear in that, but I cover that off in the letter. So I've got an audit trail, and then on the day of the hearing, I say to the person, as per the letter, I'm going to record the meeting. I'm going to start the recording, and then, a bit repetitive, but I go through the process. I do all the introductions and say at the very front end, we've agreed, and you were given advance notice, we are recording the meeting, and this is the reason why.
Thank you. Are you all right just for a bit of time?
Yeah, of course.
Some more stuff. Okay. So Rachel's asked, if accompanied by a union to the hearing, does the union also have to be present when the outcome is delivered, or can we deliver without having to wait for union availability? I.e., is there a right to be accompanied at outcome delivery if dismissal is the outcome?
It depends on your policy. That's the first thing I'll say is if well, it depends on your policy and I suppose what you've agreed with the union at the point of recognition. So, if you've agreed with the union that actually your disciplinary process will look like you invite someone to a hearing, they attend the hearing, you take an adjournment, and then you reconvene at a later date to deliver the outcome, and that the employee then, and if you do that, yes, I would absolutely suggest, even if it wasn't in your policy, if you're going to reconvene, to communicate an outcome, that that person should have their companion with them. But as I say, check what your policy says, because there's not a requirement. If your policy doesn't say that and you haven't agreed anything with your trade union at the point of recognition, then there's nothing wrong with you adjourning and saying to the employee, we will write to you with the outcome. Particularly if you're dealing with a gross misconduct matter where they may be they're on a period of suspension or full pay, they will go home and you will write to them within 48 hours most typically to confirm the outcome. So yeah, it depends on your policy and what you've agreed with your trade union. But if there's nothing in the policy that says you will do that, and there's nothing agreed with the union that says you will do that, then there's nothing wrong with you adjourning and writing to the employee to confirm the outcome of the hearing.
Corby's asked, if an employee has received a first written warning for attendance and they trigger another disciplinary hearing for attendance, where they may receive a final written warning, should the chair of this hearing be different to who chaired the hearing the first warning was issued?
I mean, yeah, I would say, you could argue, well, actually, it's two separate matters. So even if the line manager who issued that warning is going to be the same person that chairs at a later stage, you can't avoid that, and there's no reason for you to do that. The only time I might say actually might be able to get somebody else if that happens in very quick succession. Now, if you're talking about, the first written warning was issued in Jan, and then you're looking at potentially issuing a final written warning in September of the same year, then no, there's a huge amount of time has passed that I would say wouldn't make that an issue. The only time it would become an issue is if the employee raised it as such. That being said, what I would say is if you're dealing with matters in quite a short period of time, it might be helpful if you've got the management headcount to do it, it might be helpful just to look at getting somebody separate to look at the second issue, so you avoid anyone saying, oh, well, the chairperson dealt with the issue and they issued me with a first written warning and that's clouded their judgment and they weren't able to look at the evidence objectively. So,
okay. Hella's asked, if the respondent asks for witnesses to be present during the hearing, does the chair decide if witnesses should be called or not? For instance, when the concern is related to sexual harassment and the allegations have not been disputed by the respondent.
Yeah, I mean, look, if you're dealing with misconduct, there's nothing wrong with a respondent is able to call witnesses and ask those witnesses to present at the hearing. What I would say, no, you're absolutely right, is if you're dealing with complaints or allegations of sexual harassment, and the respondent says, well, I want the complainant to come into the hearing and to, give evidence during that hearing, the complainant might feel, unable to do that for obvious reasons. And I would say what you would do is you would have to adopt a very reasonable approach as an employer. You have a duty of care to all parties, the respondent and the complainant. So under those circumstances, I would suggest that no, you might want to really give consideration and take proper advice on how you should proceed. My view is, if that would happen with me, I'd be saying, actually, no, I'm not prepared to do that. You'll have presented the evidence in terms of witness statements and so on, and I'll say that is sufficient, because we're not going to actually allow for the complainant to be put in a situation where she feels that potentially she's being victimised for raising concerns, albeit not by the organisation but by the respondent. But again, it's a really interesting point. It's something I'd say, even these things that on occasion I would take advice from, say that let me just get a second opinion on that. But my gut reaction is no, I wouldn't. If you've got a witness statement from the complainant, as an example, and it's a detailed witness statement, you've recorded the meeting, there's a clear transcript, then actually that should be sufficient. And if the respondent has they're challenging particular statements made by the complainant, there's nothing stopping you going back and sense checking that with the complainant. But I certainly wouldn't want to put a complainant, particularly regarding sexual harassment, in a situation where they either feel unsafe or they feel they've been put in a situation where the respondent has been able to intimidate them for bringing or raising valid concerns.
Couple of bits now, Nathan, I promise.
That's fine. No, don't mind.
Rebecca's asked, do you always have to adjourn the meeting before making a decision, even if it's a simple meeting, i.e. trigger point for absence and there's no mitigation and the penalty is going to be a first written warning? If so, would 10 minutes be sufficient?
Yeah, no, I always recommend you take an adjournment because essentially, no matter what you're dealing with, even if it's low level and it will be straightforward, you want to demonstrate you took time to just think about and reflect on what was discussed. So if you're dealing with a very straightforward matter, it might be that it is, it could be that it's appropriate that you just take an adjournment for 30 minutes or an hour to just sit with the evidence that was presented to the employee and the responses you've just captured. Um, One of the things from my perspective is just making sure that if you are going to make a quick decision, is that you have, there are notes and records that you can refer back to help shape your decision making. But yeah, I haven't got a particular issue if you're not dismissing somebody to make an adjournment to adjourn and make a decision on the day. I mean, my preference always is adjourn, and then within a couple of hours, if it's a straightforward matter, you could write to the employee, give them a letter confirming the outcome rather than reconvening in person. But if you're dealing with a matter that could, certainly final written warnings, certainly where you're considering dismissing somebody, I absolutely advise, as a blanket approach, no, you take an adjournment, don't make a decision on the day. Even if it, some gross misconduct matters are very straightforward. Take 24 hours to consider your position, to review the evidence, reflect on responses made by the respondent during the hearing before communicating the outcome. If it's a particularly complex matter, as I say, it can sometimes take 48 hours or more to make your decision. But it's important, whilst that might feel like you're protracting the process, it's a really important point because what you don't want to do is be in a situation where an employee makes a claim and suddenly you're reading their ET1 and they're saying, actually, it was predetermined, it was prejudged, I went through, we discussed a lot of information, and actually all my employee did was adjourn, and within 10 minutes I was told I was being dismissed. So absolutely avoid that would be my advice. Demonstrate you've taken a reasonable amount of time to consider your position. It will go a long way to mitigating any risk of, or, will certainly go a long way to defending a claim if you are, subject to one.
Nathan, I'll just make this the last question, and then if anyone's got anything else after this, then are they all right to just drop you a quick email?
Yeah, of course.
Right, so the last question, as part of an investigation, an expired warning was referred to due to being issued for similar reasons in a current case. The TU, hold on, let me think, screen's moving. The TU rep commented that this should not have formed part of the report as it has expired, but the investigation officer found it was a repetition of behaviour that had not been learnt from. Who is right?
Yeah, it's a really good point. There's something telling me, and I can't remember. There's some case law. I might have to go and double check. But my view is, ordinarily we shouldn't be. Yeah, once a warning has expired, we shouldn't be necessarily relying on that to work or to escalate our way through the disciplinary process. So I certainly wouldn't say, if somebody had a first written warning that had expired, that we would say, well, actually, because you had that first written warning, we're going to give you a final written warning. So what I would say is you might be that you say, well, actually, we're going to take that into account. There is a pattern of behaviour here, but you wouldn't necessarily use it to escalate or to increase the level of warning you're going to issue. What I would say is to take advice on it, though. I think that's a really interesting point. But
No,
my default position is, yeah, you wouldn't necessarily, if it's expired, it's expired.
Marco's put on there is case law on expired warning. It was admissible.
Do you know the name of the I can't remember the name of the case. Does anybody know? I'd have to go. We'll have to go in and check. But I mean, as a matter of if anyone does, put it in the comments. But as a matter of good practice, what we would say is no. If the warning has expired, you wouldn't necessarily look to automatically rely on that. And that's certainly something I would take advice on. Say, look, we've got an expired warning. I suppose it also depends on how old that warning was. When did it expire? But as you say, what I would be looking at considering is actually, yeah, does this demonstrate a pattern of behaviour that gives us cause for concern? So it's something I certainly would take advice on, and that's where for me, obviously, I would go straight into our employment legal services team in that regard.
Okay, brilliant. Right, I'm going to do a clause now. So, thanks very much to everyone for attending this afternoon. I'm going to send out some correspondence to everyone that's signed up, and I'll put a post on LinkedIn. So, if you'd like a copy of the slides or recording, then please put a comment against the LinkedIn post. Our next event is on Thursday, the 11th of September, and is called Declutter and Rejuvenate Your Leadership for Success. A link to sign up for this will be included in the email. If anyone is recruiting, we've also got accountancy recruit, FD recruit, exec recruit, and charity recruit within the group. But otherwise, I'd just like to say a massive thank you, Nathan, to you for putting the time and effort into organising the event, and also to everyone for tuning in. Thank you.